Good morning. Again, I am Paige Nichols, and I represent the defendant appellant John Robinson. Chief Justice Nuss, may I please reserve 10 minutes for rebuttal?
10 minutes is granted.
Thank you. May it please the court. The state took all the wrong roads to the death penalty in this case. The state relied on killings that were too old and too disparate to fall within the scope of the capital statute. The state relied on an aggravating factor that, as defined by this court, did not fit the facts, and the prosecutor decided that he knew better than any court how to conduct himself at trial. I would like to talk first this morning about the prosecutor's misconduct and then move on to the more cerebral questions about the scope of the capital statute and the aggravating factors. 10 months before this trial, this court decided Kleypas and warned prosecutors that they have a heightened duty in capital cases to avoid misconduct. 5 months before this trial, this court decided State v. Henry and reversed a murder conviction because of the misconduct of the very prosecutor who tried Mr. Robinson. 3 days before this trial, this court decided State v. Abu Fakir and held that once again that prosecutor had committed misconduct in a murder case. That's 3 pretty loud warning bells, and yet, what did this prosecutor do right out of the gate during closing argument in the guilt phase? He created an inflammatory imaginary script. And one must wonder, did that poor, fat, disabled Debbie Faith, did she watch her mom get killed? This is our claim 54. Debbie Faith was the teenage daughter of Sheila Faith. The Faiths left Colorado in '94, were never seen or heard from again until their bodies were discovered alongside a third victim. But there was no evidence that they were killed at the same time, in the same place, or in view of one another. And so there was no evidence to support this speculation that Debbie Faith watched her mother's death. It was nothing more than the kind of blatant appeal to emotion that this court forbade in Kleypas, especially in a capital case. And this argument was so inflammatory that the trial judge not only sustained defense counsel's objections, but refused to give a curative instruction because he thought it would do more harm than good. Unfortunately, not giving the curative instruction probably made things worse because the prosecutor made the comment, the lawyers were then, the defense lawyer objected, the lawyers went up to the bench, and the judge said, hey, that's too speculative and you're getting into victim impact, but I'm not going to give a curative instruction because I don't want to call more attention to it. So the lawyers go back to their places and the prosecutor carries on. So from the jury's perspective, absent any sustaining of defense counsel's objection that they heard or curative instruction, it must have seemed as though the judge had endorsed the argument. And this is a jury that's been through 3 weeks of trial and has seen objections sustained and has received curative instructions. This argument about whether Debbie Faith watched her mother's murder was particularly harmful at sentencing because it gave the jurors a narrative to go with one of the killings, and it really operated like an uncharged aggravating factor. There were no killings alleged to have been individually aggravated in this case, heinous, atrocious, or cruel, until the prosecutor imagined that evidence into existence by painting a picture of a wheelchair-bound teenager watching her mother get murdered. That misconduct was enough alone to infect the sentencing phase, but it was really only the tip of the iceberg. In addition to telling prosecutors, don't create imaginary scripts, Kleypas told prosecutors, don't tell the jurors that the defendant's demeanor is evidence of lack of remorse. What happened here? The prosecutor told the jurors that Mr. Robinson's demeanor indicated lack of remorse. When the defendant cried, this is our claim 80. When the defendant cried, he only cried one time. He didn't cry when there was testimony about Lisa Stasi. He didn't cry when there was testimony about Isabella Levica. He didn't cry during testimony about Suzette Troughton, and the prosecutor goes through each and every one of the victims and tells the jurors that the defendant did not cry during witnesses' testimony about those victims. Now, Under Kleypas, this argument that silence equals deathworthiness is an impermissible comment on the defendant's silence and right to remain silent. At the motion for new trial, the prosecutor said, well, didn't say, but in the prosecutor's response to the motion for new trial, the prosecutor admitted these statements were arguably irrelevant and they were perhaps ill-advised, but they're not grounds for a new trial. Well, now the state just says Kleypas was wrong on that point, but the state doesn't offer any authority for the idea that a prosecutor can just go ahead and make an argument contrary to what this court has said just because the prosecutor thinks this court is wrong. And really, the cases cited in the state's brief for overturning Kleypas on this point aren't persuasive because they're fact-bound, as all misconduct cases are, and they don't address the effect of this prosecutor's comments in this case. The Blacksher case from California that the state relies on involved a defendant whose bizarre behavior during trial was on full display to the jury throughout the trial. It was so readily observable that the defense lawyer commented on it in his closing argument as well. Here, there's no evidence that Mr. Robinson was not crying during any witness's testimony at trial. When the prosecutor stands up and says he never cried, the prosecutor's basically testifying to facts not in evidence. We can presume the jurors are watching the witnesses for the most part while they're testifying. And so that's something that is different about the Blacksher case. The Blacksher case also says the defendant's demeanor might be relevant to rebut evidence that the defendant has put on. Well, that may be so, but here the defendant did not put on evidence of remorse and did not argue remorse. So when the prosecutor argues lack of remorse, he's not responding to anything that the defense brought up, and he's creating yet another unstatutory aggravating factor of lack of remorse. Again, this argument was directly in violation of what Kleypas said, don't do. Lawyers who don't like the rules are supposed to obey now, grieve later. But here the prosecutor chose to disobey now, claim harmless error later. So I'd like to sort of jump forward and talk about that harmless error. We've set forth in claims 80 through 90 a number of misconduct claims in relation to the sentencing proceeding, but I imagine this court's real question is, well, we may find misconduct, but isn't it true that the aggravating factor of 6 murders is so weighty as to overcome any harm from the misconduct? Kleypas says that in order to sustain a death verdict over claims of multiple misconduct, the state has to convince the court that that misconduct had little or no likelihood of changing the jury's penalty verdict. So if this was really such a slam-dunk case for the prosecutor, then why did the state need to push the envelope repeatedly? More specifically, here Mr. Robinson relied heavily on his family's love and his proven ability to live peacefully in prison as mitigating factors. And the sentencing misconduct, much of it went straight to the heart of those mitigating factors. For instance, why should the jury keep a man alive for his wife if that wife is a fool and an accomplice, like the prosecutor seems to think? Or why should the jury allow a man to live to see his 8-year-old granddaughter grow up when the prosecutor says he took that girl to his kinky sex liaisons? And why should the jury trust the prison system to protect potential victims from a killer when the prosecutor has told us we're not sure whether that system is going to give that killer his lure of choice, the internet? If we know anything about juries, it's that they are unpredictable when it comes to making life and death decisions. This court said it in Carr, it only takes a single juror to grant mercy, and the prosecutor's misconduct at the penalty phase made that granting of mercy impossible, and the penalty phase was unfair because of the misconduct. With the court's permission, I would like to switch gears and start addressing the scope of the statute, but I see that Justice Johnson has a question.
I do. You cited the Kleypas for the test on reversibility for the prosecutorial misconduct.
Yes.
Is that affected any by our Ward decision, where we talked in detail about how we're going to test it and harmlessness, and whether this is a constitutional error or a non-constitutional impacts our test, or do we, because it's death penalty, we use a different test?
It's a little bit different in the death penalty arena, and Kleypas discusses that at length. But I also don't think that this is that inconsistent with the word pardon me, standard. I think normally, in Kleypas, for instance, the court did not discuss that three-pronged prejudice standard that had really been in place before Kleypas, but noted that instead, because of the Eighth Amendment considerations and because of, pardon me, just the different sorts of decisions the jury's making at penalty. They're making both factual decisions and really a value judgment, that it's a little harder to talk about harmless error in the same way in that context as we do during the guilt phase.
I'm interested, you just said in concluding your statements about prosecutorial misconduct that it made the granting of mercy impossible. How do you jump to that conclusion? What made the granting of mercy by this jury impossible? Prosecutors making an argument, counsel for Mr. Robinson's making an argument on mitigators. How does that leave us to the conclusion that it's impossible based upon his statements?
Well, you've got me there with perhaps making an overstatement, and I don't think I have to show that it was impossible, but so I apologize for overstating.
I was just, that's what you said.
Yes,
okay.
Right, I did. And what happened here with all of these types of misconduct was the prosecutor was building up so much emotion that was unconnected to the facts, to the mitigating factors and the aggravating factors, that it essentially would have distracted the jury from its ability to rationally weigh the factors, and including the factor of mercy. If the court is ready to switch gears now, I'd like to address some of our statutory claims, specifically the temporal scope of the capital statute, the meaning of common scheme or course of conduct, and the scope of the aggravating factor. Before I start, I'd like to take a moment and lay out the structure of the capital charges and point out some aspects of them relevant to the scope discussion. And as we talk about the charges, it might be useful for the court to refer to our brief at page 216, if that's convenient. We've set out a chart at page 216 detailing the charges and summarizing the narratives of each killing. Here we have 2 counts of capital murder. Each of those counts pairs a different principal victim with the same 4 predicate victims. And so the Suzette Troughton count pairs the killing in 2000 of Suzette Troughton with the killings of Beverly Bonner, Sheila Faith, Debbie Faith, and Lisa Stassi. And in the Levicka count, the killing of Isabella Levicka in 1999 is paired again with those same 4 predicate killings, Beverly Bonner, Sheila Faith, Debbie Faith, and Lisa Stassi. And those 4 predicate killings were all cold cases. They were all killings in which the state was unable to place the deaths of these victims after the effective date of the capital statute. That leads to my first question. Does the capital statute apply to multiple killings that straddle the effective date of the statute? This is claim 50, and it's really purely a legal claim of statutory interpretation. The defense position is simple. The legislature wrote a statute that by its terms applies prospectively only. There is no indication in the language of the statute that it is meant to reach 2 acts that predated the statute.
What about the state's argument that it straddled 94, July 1, 94, the effective date of the statute, and that the capital crimes weren't complete until the principal crimes were committed?
The state's argument relies on ex post facto cases that are really about what the legislature can do. Our argument is about what the legislature in fact did. And the state doesn't offer any authority for the idea that continuing offenses that straddle a statute are an exception to the statutory rule of interpretation that statutes apply prospectively only unless their terms clearly state otherwise. Scalia and Garner say it in their book about statutory interpretation. All can agree that statutes imposing new criminal liability are presumptively inapplicable to acts engaged in before their enactment. And this court has recited that presumption literally hundreds of times. It's unusual to see it at play when we're talking about elements in a criminal case.
That's the ex post facto presumption, right? That you just recited from Scalia Garner.
No, that is the statute, the canon of statutory interpretation, and they actually make it clear in that chapter of the book that this applies whether or not that interpretation would violate ex post facto. This
Okay.
court does it all the time, finds that when new sentencing statutes, for instance, benefit the defendant, if they don't state that they are retroactively applicable.
We have
then-
numerous tests to decide whether or not we can apply a statute retroactively, correct?
Oh, sure, but most of those, oh, pardon me.
So with that foundational question, if the state's argument, not with respect to a continuing offense, but with respect to when an offense becomes completed, if we were to accept that argument, it would follow then, would it not, that in fact the application of the capital statute here was not being applied retroactively? Because in fact it's only applied at the final killing, what you described as the principal killing in each charge.
So that would be taking a position that a statute doesn't apply retroactively so long as the final act occurs after the passage date of the statute.
Well, I guess my question, just to sort of cut to the heart of it, is when did these crimes that were charged occur? In your view, when did those crimes occur?
As they were charged, they began to occur with the killing of Lisa Stasi in 1985.
How could they begin to occur when not all of the elements have been met?
The state's taking the position this is a continuing offense and that it started in 1985 and it ended in 2000.
I understand the state has two alternative arguments. One
Right.
is a continuing offense and one is a
Right.
completed offense. And for right now, at least, what I'm interested in is their argument with respect to when the offense is completed.
Sure, the offense of capital murder, if the statute can apply to pre-statute killings, it surely didn't apply until 1999 when the first post-statute victim was killed. There were murders that predated the statute, but capital murder didn't exist until after July 1, 1994. And one reason I raised the Federal Sex Offender Registration and Notification Act cases is because those were the only cases I could find where this kind of problem presented itself to a court. And in those cases, there's a very similar situation. There was an element of, this is the Carr versus United States case, and the Husted case out of the 10th Circuit cited in our opening brief. There was a situation where there was an element committed by defendants that predated the Sex Offender Registration and Notification Act, and that was interstate travel. And then there was an element of failure to register that was a continuing element that occurred after the passage date of the statute. And the 10th Circuit and the U.S. Supreme Court applied a rule very similar to the one I'm discussing here of pure statutory interpretation to conclude that the statute doesn't say that it reaches back to embrace pre-statute acts, and therefore we can't read it that way because of the rule of lenity and because of this rule of prospectivity.
Let's back up even further. You would agree with me that, 3439A6 applies to serial killings. It criminalizes serial killings, right?
Sure.
Okay. How would it make sense if that's what the legislature is trying to criminalize, that we wouldn't start counting the bodies until July 1 of 1994?
The legislature just didn't write it that way. That's all. From here on out, serial killers will be subject to capital murder charges. Now, we could take the state's position, and if the course of conduct is a continuing element, then maybe BTK himself would have been subject to the capital statute. But nobody's arguing that it goes quite that far. And my argument is basically a simple one, that either the killings have to start after the passage date of the act, or there has to be some exception to the rule of prospectivity.
Why wouldn't the language in the statute about, and I have it here, but I don't want to put my glasses on to look at it, but it's the course of conduct type of language here. Why doesn't that just signal that when you tie that to what is the obvious intent to criminalize serial killings,
Mm-hmm.
why doesn't that tie the two together and let you know that you can look back to any premeditated intentional killing that occurs in this course of conduct?
Simply because it's not clearly stated.
How clearly stated does it have to be,
Well,
in your view? Does it have to be explicit, or can we look at the words and see what makes sense?
since we're talking about a criminal statute and one that increases penalties from life to death, then the rule of lenity would suggest that it needs to be explicit. Killed more, having, the intentional and premeditated killing of a person having previously killed one or more persons. We have plenty of examples of statutes where the legislature looks back in the statute. Criminal possession of a firearm by someone who has been convicted. The sex offender registration statute applies to people who were convicted of listed acts on or after a particular date. And so the legislature knows how to be clear about such things. And there's not any statutory history that would suggest a look back kind of intent. And again, the language of the statute is the same for all of the subsections. Killing of a law enforcement officer, killing of a person pursuant to a contract, killing of more than one person as part of a common scheme or course of conduct. So that's where we are with this issue. And
Let me ask you one other question about this. When I was reading the jury instructions in this case, it prompted me to go back and look at old pics to see how those were set up. And what it appears to me is that the jury instruction that was used at trial does conform to what Pick said at about that time. Mm-hmm. Would you agree with that?
yes,
And I say that because there are some newer versions of Pick that don't seem to conform to what you guys did at trial. That would suggest that it fits within what the state is arguing, that there's a primary crime. I mean, when you look at that Pick instruction that you used, that there's a primary crime, and that would be the post-94 killings, and then some sort of predicate crimes later, which are the older crimes. And so it seems to me that everybody knew what this statute was supposed to be doing at the time, and was interpreting the statute not the way you want us to, but the way the state wants us to. Is there anything that I shouldn't be reading into that, or am I going too far with Pick?
Well, first, I think, are you referring to the elements instruction?
Yes.
Where at the bottom it says this act occurred during this limited period of time? Right, those instructions do say that. Maybe that complicates things, but before trial, after the preliminary hearing, defense counsel did move to dismiss the charges, in part because of the pre-statute killings being linked in, and made this very argument for trial. And so the state, so there was really not an agreement among the parties before trial that this is how the statute should be interpreted. There had been that challenge to the charge based on its inclusion of pre-statute killings, and that challenge was denied. But I understand how that instruction seems to complicate matters, especially if this is a question that the jury should be deciding.
And wasn't there also a motion to arrest judgment filed?
There was, although I
Not on this
don't
issue.
think it was on this issue. Right. Now, if I'm right, then I think the state comes pretty close to conceding it can't place those killings after the passage date of the statute. In its brief, the state simply says it is unclear when the predicate victims were killed. And in fact, its evidence is on each and every one of them points to pre-statute killings.
And there's nothing about this pre-statute killings of Ms. Bonner and the Faiths and Stassi that this statute impacts the treatment of those cases. I mean, it's not a retroactive application into the conviction or trying to do something different to them to those particular acts. Isn't that right? In other words, the death penalty statute doesn't impact the way the cases against Ms. Bonner, or not against, but that includes Ms. Bonner, the Faiths, and Stassi, the homicide cases on those.
Right.
So there's no retroactive application to them. And the statute's in place when the killings of Troughton and Lewicka occur. And so how does that prejudice, or why is there a retroactive application at all when we look back to those? Mr. Robinson knew what the statute was at the time post-1994, July 1994. This statute in no way impacts his criminal responsibilities for Bonner, the Faiths, or Stassi. And all it impacts is the present application of the statute as it pertains to those crimes, if I'm making myself clear. I don't understand why there's a problem here with that.
I'll offer an answer, and if I've misunderstood
Okay.
the question, I apologize. We have a small complicating factor here in that the Faiths and Beverly Bonner's bodies were found in Missouri, so they actually could not have been prosecuted in Kansas, and those killings were prosecuted in Missouri. But I'll just
Right.
set that aside for the moment. Yes, Mr. Robinson could have been prosecuted for Lisa Stassi's murder, and in fact was, separately from the capital charge. It also looks like Suzette Troughton and Isabella Lewicka's killings perhaps could have been charged in a single capital count, because both of those postdated the statute. But they weren't, because the state wanted 2 capital charges, and so the state propped up each of those post-statute killings with these pre-statute killings. I'm sure I had another point that was going to get to the heart of the matter, and I talked myself around and lost it. Did I address any part of your question there?
I think you did, but I still didn't get an answer to this statute doesn't. There's not a retroactive application to the homicides involving
Yes.
the people that were involved in the common scheme.
Yes.
So they're not. There's no retroactive application there, and there's really not a retroactive application to the current crimes involving Troughton and Lewicka. These are post-death penalty crimes charged with capital offenses, and they're utilizing actions that took place pre-capital amendment, and there's no retroactive application to those. I mean, it doesn't impact those.
Except that those counts wouldn't have been capital had those other killings not been added to them. And I heard Your Honor speak of notice, and I want to be clear that that's not part of our argument. It's not a question of whether there was notice that if you kill one more time, you will be subject to capital murder. It's really simply a matter of if the legislature wants us to embrace elements that predate the statute, they need to say so more clearly than they did here.
Can I draw you back to something you said a moment ago along these same lines when you referenced the statutes criminalizing a felon in possession of a firearm?
Okay.
And I thought I heard you say that this case, that our capital statute is distinguishable from those statutes in that those statutes use language like possession by a person who has been convicted.
Mm-hmm.
Did I understand you correctly to say
Yes,
that? So
yes.
essentially, as I understand your argument, you're saying those statutes set up multiple elements to the crime. Someone who has been convicted who then possesses.
Mm-hmm.
And that may straddle the effective date of the statute. And courts have routinely said that's fine,
Mm-hmm.
right? Mm-hmm. And it strikes me that your argument here is really that our capital statute really only has one element, which is the killing of more than one person in a common course of conduct. Is that a fair characterization of your argument?
I'm not sure it matters to the argument whether you see those as 1, 2, or 3 separate elements.
Right. Well, this gets to what your very first description of a principal crime,
Yes.
or principal killing, and then predicate killings.
Yes.
And help me, in order to pursue your argument, it seems to me that you have to distinguish that circumstance from the felon in possession circumstance. I mean, why isn't it the same? Why isn't it directly analogous to a felon in possession?
Because
this is a principal killing that happens after the effective date of the statute by a person who has previously killed others in a common course of conduct.
Had the statute said that, who has previously killed, I would not be making this argument today. That is the difference, the lack of clarity of language in the statute.
So your argument
itself.
really hinges on the very narrow grounds of the lack of those specific words being in the statute.
Or words like those, yes, words that we read and immediately understand to embrace pre-statute acts.
And it goes beyond that. We don't, as a matter of statutory construction, imply retrospective application.
Exactly.
And we don't imply a continuing course of conduct or a continuing crime. A crime is not implicitly a continuing offense. We require the legislature to say so
Yes.
as a matter of statutory construction.
Yes.
So we don't start from zero. We
Right.
start from the place that the legislature needs to tell us.
Right.
And then, is there enough to imply that they were trying to tell us?
Right.
Okay.
Let me ask you about some of the other subsections of the same capital murder statute. Would you take the position that, for example, like the first one is a murder that occurs in the commission of a kidnapping, I think is the first one. If the kidnapping had started on June 30 and the killing on July 1 of 1994, would you tell us then that the kidnapping started before the statute went into effect, and so we could not have capital murder in that instance?
I believe I would.
Ms. Nichols, I'd like to move you to another issue, if I may.
Sure.
Specifically, there's a recurring argument in your briefs having to do with the defense essentially being surprised by the state theory during rebuttal closing. And I'm having trouble grasping that argument because even the complaint, even the charging document talked about a common scheme or course of conduct. And it just seems like there was notice throughout. And in fact, defense counsel argued that point pretty thoroughly during closing. So how is there some kind of unfair surprise or prosecutorial misconduct and springing that on the defense?
It's true, of course, they knew what the charges were and to some extent what the evidence would be. But what happened during the prosecutor's closing argument during the guilt phase, and this is our claim 61, the rebuttal argument claim, that the state in its initial closing argument did not argue anything about that all-important element, course of conduct, and saved that part of the argument for rebuttal. So the evidence surely is still the same, and defense counsel did address that element during the defense closing argument, but what the state did in its closing argument was introduced the themes of luring, exploitation, concealment, and disposal, and argued that certain evidence fit those themes that the defense did not get a chance to rebut with its own view of the evidence. So I understand what Your Honor is saying about defense counsel had a certain amount of notice of what might come up, but I imagine had I come in here and asked for 55 minutes of rebuttal argument, that may have been frowned upon and probably would have felt quite unfair to the state. And I want to point out as well that that is a direct violation of the district court rule about rebuttal argument. So that's another example.
Was there an objection?
I don't believe there was an objection
And
to this one.
that was signaled, I think, Mr. Morrison at the end of his first argument says,
Yes.
when I come back, I'm going to tell you,
Yes.
we're going to talk about the course of conduct. And so, not too much of a surprise there what was going to happen. And there was no objection by defense counsel, right?
Right. If I could, I'd like to move along to the question of the definition of common scheme or course of conduct and whether the evidence in this case was sufficient as a matter of law to meet that definition. And I'll start with just some working definitions.
If we may, just real quick, I just had a very fast question on this. Had the state charged this as connected together?
No.
I know they did not, but had
Oh,
they done so?
I'm sorry.
That's okay, I wasn't quite finished. Had they done so, would this be adequate, the evidence here that they were connected together?
It would be, my thinking on this has changed just a little bit since Smith-Parker, because I think in Smith-Parker, this court found the crimes in that case, which were far more closely related, temporally speaking, than here, found them connected together for joinder purposes. But it seems like connected, I don't know what connected together means.
Okay, it seems broader to me than common scheme
Yes.
or course conduct.
It
Okay.
does, and it did to me after I read Smith-Parker. I wasn't necessarily sure of that before that case.
Okay.
But here, we have simply a charge of common scheme or course of conduct linking all of the killings listed in the capital counts. And common scheme, this is my proposed definition, and we can talk further about what those things might mean, tends to be used to mean a common goal, motive, or purpose. Course of conduct tends to be used to mean a pattern of regular and similar events. And by regular, I mean repeated and close in time, and by similar, I mean alike in features like time, place, manner, purpose, victim characteristic. So we've argued the killings are too different. The state argues they are alike enough. But the state doesn't properly take into account that 9-year gap between Lisa Stassi's disappearance and the 94 killings, and that 5-year gap between the 94 killings and the killing of Isabella Levicka, followed by 6 months, and then Suzette Troughton. Those temporal gaps are more important than the state would allow. Without those, the evidence weighs heavily against a finding of course of conduct. And this goes back to my definition of course of conduct being a pattern of regular and similar events. If one of those is missing, as regularity is here, then the state must make a stronger showing of the other. And this idea comes from the state's own cases. For instance, the North Carolina case, Cummings, that is in actually both our briefs, the North Carolina court says the further apart the acts are temporally, the more incumbent it is upon a court to carefully consider other factors in determining whether acts of violence make up a course of conduct.
And the court is making that determination rather than the jury?
Well, the jury should be making it as well. Unfortunately, this jury didn't have any guidance on
Well,
what
I
course of
understand
conduct.
that, but what you read me indicates it's as a matter of law rather than factual issue.
In Cummings, the court affirmed a capital conviction that was based on course of conduct. And in there were killings that were 25 months apart. And so the court was, this discussion was in a section where the court was noting that the jury in the Cummings case had been given an instruction defining course of conduct. So the court first says, well, here, the jurors were properly instructed, and then the court does its own review of the evidence as a matter of law. And so, yes, that was a long way around for me to say I agree that that was a section where the court was talking about its duty in reviewing the evidence. And the Corwin case out of Texas also says, as the time and distance between murders increase, and as the motive or modus operandi vary, it will become more difficult to say with certainty that the murders occurred pursuant to a course of conduct. And taking this view of requiring greater showing of similarity when regularity is missing is also consistent with the rule of lenity, avoids vagueness problems, and there's really just no authority in the cases out there analyzing course of conduct for capital murder purposes to find a course of conduct when the temporal gaps between the killings are so great, the motives apparent for the killings are so different, and the character of the defendant's relationships with the victims are so different. One thing it's crucial to remember for this claim is that the state charged all of those predicate killings in the conjunctive, and so the state was required to prove that each and every one of them was part of that course of conduct. If any one of those killings falls outside the pattern, the capital charges fail.
Why couldn't the jury have just, or why wouldn't the jury have considered every argument you just made over the course of the last 3 or 4 minutes? You're asking the court to step in and say, as a matter of law, the court should have essentially either taken this question away from the jury, or I understand you also make an instructional argument with respect to defining these terms. Mm-hmm. But it strikes me that an ordinary reasonable person or reasonable juror could, and probably would, come to the same definitions that you just gave us for these words. Why wouldn't they just use their ordinary reasonable understanding of these words that are common words, mm-hmm. and apply those definitions to the evidence that they heard?
As I hope is pointed out in the vagueness section of our brief, those terms have different common meanings. This court has often used the phrase course of conduct simply to describe behavior generally. And so without that instruction, the jury may well have thought that the course of conduct was proved by, as the prosecutor argued, that common thread running through all the murders, John Robinson. And we know that the statute requires more than that. Not sure if I addressed your question.
That's fine.
I'd be happy to try some more. I would like to jump to the question of the scope of the aggravating factor if there are no more questions about the scope of the capital statute. Now, this is an argument that even if the evidence is sufficient to prove the capital charge, it was insufficient to prove the aggravating factor, as this court has defined that factor in State versus Spain. And I understand at first they look pretty much like the same thing, right? The capital charge was killed more than one person. The aggravating factor was killed more than one person. But we can't really stop there because, as Justice Breyer pointed out, the capital charge was killed more than one person in multiple acts or transactions, whereas in Spain, this court really defined that factor to be killed more than one person in the same act or transaction. So in Spain, this court held that evidence of a murder and a kidnapping that were hours and miles apart were merely a series of discrete transactions that were too remote in time, place, and nature to prove this same aggravating factor. If the criminal acts in Spain were not tied closely enough together, then neither were the killings here, and Mr. Robinson must simply be acquitted of the death penalty. The state does not respond to our statutory arguments here, but merely insists that the legislature meant to punish serial killers with the death penalty, which the legislature very well may have meant to do, but in importing a factor from the hard 40, hard 50 cases into the death penalty scheme without changing that factor at all, the legislature is presumed to have imported this court's interpretation of it. I have some minutes left, and I'd be happy to answer questions on issues that I have not addressed.
I've got a few questions. Excuse me. Our precedents don't answer the question about the standard of review for penalty phase instructions when there's been no objection. Do you want to address that question? Any other precedent from other jurisdictions we should look to?
I know that question was reserved in Carr or Klebus.
Carr,
yes,
I think.
That was reserved in Carr. And It may depend on the type of error, although I think we only have one penalty phase instructional error that was not preserved, and that's the error in the supplemental brief.
Right.
Okay, and that error definitely has due process implications, at least insofar as the jury was told that it essentially that voting for life was perhaps optional rather than mandatory. The question of reversibility, I believe the court's asking. Reviewability, we can raise the issue under 2166-19, but the question of reversibility is whether the plain error applies or the error for preserved error. Is that the question that Your Honor is asking?
Yes.
Okay. I don't know that I have much to add to that other than what we've put in our supplemental brief, but
Okay.
the problem with that instruction 12, which is the instruction that said if the state wins the weighing contest, you shall vote for death. If the defense wins the weighing contest, you should vote for life, first, it's clearly a misstatement of the law. That's not what the statute says. And I don't think we even need to get to the discussion about the should question and whether that intrudes upon the jury's right to nullification. The problem really is that, I may have said that backwards.
Yeah, I think shall is the one
Yes,
that
the shall
may
instruction.
have implications for nullification.
Yes, our bigger concern here is with the should instruction. And the case that I have cited in there for the proposition that that error is structural error, not subject to any harmless error review, is actually a guilt phase case. And so I apologize for not having that case on the tip of my tongue here. That was the State versus Smith case out of Washington that held that kind of error is not susceptible to a harmless error review because it goes to the heart of the job the jury is trying to do. And so, pardon me, that's one reason to not
That's
use.
the best you got, though, on that one.
It's the best I have today.
Okay.
If the court wants more paper from us.
I have a couple of other questions on other issues. I think in your brief you said that the statutory exclusionary rule requires suppression of any illegally seized evidence, but it says that the defendant may move for suppression. And it seems like saying it requires suppression when the defense may not even move for it is a bit of a stretch to me.
Well, that's
a response to that.
I see that. The response would be that if the defense does move, then the suppression is required.
Okay. Why wasn't any admission of testimony about the correspondence, the Beverly Bonner correspondence, harmless in this case, given the other evidence that came in from the different friend about the conversations that had transpired? I think you
I
argued
think this
that
might be the Sheila Faith, the correspondence
Oh,
that was
excuse
found.
me. Excuse me. Yeah, you're right.
Okay,
Excuse me.
okay, correspondence that was found.
Right.
Okay, the state was making an effort to link Sheila Faith's relationship with Mr. Robinson to those post-statute relationships and
Right.
define it as involving BDSM. And in eliciting evidence that more than 20 years previously, there was a letter of unknown authorship in her house that suggested this, violated a number of, I realized you've asked me about the harm.
Right, exactly.
I'm getting
I mean,
there.
Even if we assume it's error for however many reasons, just don't understand the harm given the other testimony from the different friend who said Sheila Faith used to have these conversations with her or attempt to have conversations with her and she didn't want to discuss it. I mean, it was about the same topic.
It's just simply one more thumb on the scale for that
Okay.
element. Yes.
Alrighty.
I've got a question as it pertains to the continuance
Sure.
aspect. Is there any particular evidence or an additional defense that your client would have presented either in the guilt phase or the penalty phase had a continuance been granted?
There was no showing after the trial of what that evidence would have been. The groundwork for it was discussed right before trial in terms of the mitigating evidence. And the case is really kind of like the State versus Haney case that this court decided not too long ago. And in Haney, this court found that a district court abused its discretion in refusing to allow a continuance for the defense to gather mitigating evidence, specifically an evaluation of the client who was subject to Jessica's law sentence. And that defendant did not make any showing of specifically what that evidence would have been.
I think we were concerned in that case because the basis of the plea was predicated on that evaluation, and he was denied that opportunity. We really don't have that. That was at least a concern I know of the court. Here we don't have that particular situation. You have a general request for a continuance because I need more time, and there were some compelling reasons for that. But do you have a burden of showing what that would have been? What additional evidence that might have come from the granting of the continuance?
Some of the cases suggest that. Not all of the cases do, but we absolutely did not make that showing.
Okay.
And why, the district court did grant the defense leave to have those evaluations done, right? The evaluations that the mitigation experts sought.
In our case, yes,
Yes.
but it was decided that there was not enough time to
Right, so that was
make
my
proper use of them.
Follow-up question. Expand on that for me. The defense team asks the judge for permission to have these evaluations performed. The district court says yes, and then the defense team changes its mind and decides we'd rather ask for a continuance, essentially, than go forward with the plan that we first proposed.
Yes, and I
Is that a fair characterization of?
Yes.
And so,
And-
how did that happen?
How does that? From the, get my chronology in front of me. From the first defense request for a continuance after private counsel was taken off the case to the start of trial, there were 3 different requests for continuances. It's clear from the way those requests came about that this was kind of a just constantly developing and changing situation. More discovery was coming in. The defense was finding out that its social worker in Chicago had fallen off the radar. And so they find themselves very close to trial, consulting with some mitigation experts who say, we have some preliminary findings that there may be a strong case in mitigation to be made, but we can't do it within this time in a way that will help your client.
And when, just in that chronology, remind me when the defense moved for permission to have Mr. Robinson evaluated.
I don't have that one on my chronology here, but I can try to get that for
I
you
think
in
it was,
rebuttal.
and you can again help me recall, I think it was closer to trial than to when.
Yes.
Okay, so that's the issue that concerns me. If the defense team thought that they could get him evaluated and the district court says okay, I mean, that's really what the complaint is here on the continuance, at least with regard to the penalty to the penalty phase, right? Because mitigation experts said we needed those medical evaluations. It just strikes me as problematic for the defense team to have received permission to do what they wanted to do and then decide on their own not to do it and instead seek a continuance, and now they're complaining that they didn't get the continuance.
Yes, and I think that the defense reasoning for withdrawing that, I believe it's perhaps in the motion for new trial, but the double-edged sword of mental health mitigation evidence is always that if you don't do it properly, the state can use it for aggravation. And so the defense was trying to scramble and put a mitigation case together, but then recognized probably that had there been an evaluation done, it would have been available to the state. But the defense didn't have enough time to do the follow-up work of getting the family
So
history
they just made
and so forth.
they've essentially made a strategic decision based on the calendar as it existed at the time and changed their minds. Is that a fair description?
Based on the refusal of getting the continuance.
Right.
Yes.
Okay.
Do you have any further presentation, counsel?
I would just sum up by saying again that this was not properly a capital case. it was not properly aggravated, and of course, the prosecutor's misconduct has no place in a capital trial. Mr. Robinson prays for a reversal of his capital convictions and his death sentences. Thank you.
Any more questions? Thank you, counsel.
Thank you, Your Honor.
Counsel, there's been some indication to me that you and Mr. Obermeyer are intending to split your time. Is that right?
That's correct, Your Honor.
Okay.
If I may it please the court, I'm Jacob Gonteski. I represent the state of Kansas, the appellee in this case. I'm an assistant district attorney in Johnson County, Kansas. With me in oral argument is Mr. Steve Obermeyer, assistant district attorney in Johnson County, Kansas. And that's correct, Justice Nuss. Given the breadth of this case, the briefs in this case, and the oral argument, we are requesting the court's permission to split our oral argument. Given the case that was just presented, we would request to be able to split our oral argument approximately in half. I would be utilizing approximately 30 minutes of the state's time with the court's permission.
With that in mind, I'll ask you what your preference is. Would you prefer to do your presentation and then the court take its break? Or do you prefer that we take our break now so that you and Mr. Obermeyer can have a free flow of the narrative?
I would prefer to go forward at this time, Your Honor.
Very well. Please proceed.
Thank you, Judge.
Counsel, before you start,
Yes.
since you're splitting your time, are you splitting subjects? Because I've got some questions and I don't want to pose them to the wrong guy.
I am, Justice Biles, and I'm glad you asked that. That was the next piece I was going to go into. I would ask that the questions on the following issues be directed toward me. If there are issues related to voir dire in this case, the denial of the request to change venue, the denial of the continuance request, any of the evidence issues related to email that was admitted in the trial, and the prosecutorial misconduct claims will all be the subjects of my presentation. Any of the balance will be addressed by Mr. Obermeyer, including how the case was charged, continuing course of conduct, common scheme, jury instructions, and so on. And with that, I will first move into a couple of issues that were addressed in the appellant's case, and I would like to start where they started, on the prosecutorial misconduct claims. There are several that are outlined in the state's brief. I would like to touch on the ones that were the subject of the first portion of oral argument here today. I believe those began with claims 54 or so. I would first like to highlight, at the close of this case, in the motion for new trial, Judge Anderson expounded upon the issues related to errors that may have been made by the prosecutor in this case. Judge Anderson was particularly cognizant that the appellate courts in Kansas are very attuned to the subject of prosecutorial misconduct. He was aware throughout the trial that that has been an issue that has been addressed extensively by this court, and he was in tune with the current state of case law at that time. He stated, quote, "I was well aware of that as we were going into the closing stages of this case. Indeed, all along throughout this case. There were bench conferences where I admonished the prosecution with respect to my rulings. Mr. Morrison didn't agree with them and was unhappy with them, but I believe I took, if anything, a conservative approach in this regard in ruling on those objections and giving the state guidance from the court." And finally, Judge Anderson stated, "As a result, I do not believe the court erred with respect to its rulings. I do not believe the prosecution crossed the line with respect to the appropriateness of remarks in closing argument. This is something I am sensitive and watchful and mindful of, and I think the record of bench conferences will reflect as much." Specifically, regarding comments about Debbie Faith and Sheila Faith and whether or not they witnessed each other's killings. That was one line in the state's closing argument, was whether or not Debbie Faith watched her mother get killed. But the evidence in this case did support that argument. This was not an imaginary script. This was not a narrative. These are not words being placed into a victim's mouth. These are not thoughts in the defendant or the victim's minds. These are valid questions given the facts that were admitted in this trial. Specifically, the facts in this trial were that Debbie Faith was disabled, she was overweight, she was wheelchair bound, from a lifelong disability that she suffered from. And her mother, Sheila Faith, was her caretaker. They were essentially always in each other's direct contact. They were always together. They were together when they moved to Kansas, when they were lured here by Mr. Robinson. And as her caretaker, Debbie Faith was always around her mother, Sheila. The evidence was, when they were found in 2 adjacent barrels on Mr. Robinson's property, the evidence from the coroner was that they appeared to have been killed in the same manner at approximately the same time. Given the state of the remains, it could not be conclusively established exactly when each was killed, whether or not it was down to the minute or within minutes or hours of each other. But all of the evidence that was on point with this issue supported the notion that they were killed at approximately the same time, and they always spent time together, including the fact that Debbie Faith had a defensive wound on, or a wound consistent with her taking defensive action on her arm.
Sheila did.
Sheila did, excuse me. Regarding that point, there's also a couple of cases that have been raised in both the appellant's 609 letter and the state's 609 letter that I believe are on point with that misconduct claim. Defense cites to the De La Torre case from 2014. In that case, it was found improper when there was a script of, "I wonder what the toddler victim thought this world was all about," before she died. That was the imaginary script. That was wondering what a victim thought was going on before she died, a toddler victim. In the state's 609 letter that was supplied a couple of weeks ago, we cited to a couple of very recent cases, the Meistus case from 2014, in which it was found there was no reversible misconduct when a prosecutor stated in rebuttal, "And I wonder, as Mr. Meistus stood above his mother, stabbing her on the bed and on the floor after she'd screamed for him to stop, was this a nightmare that's coming true? Was this the worst nightmare of hers, or was this something that Mr. Meistus had been dreaming of?" That was found to not be improper because it was supported by the evidence that was in the case. The victim was sleeping when he stabbed her. She was in her bed. Additionally, the Court of Appeals of the state of Kansas issued an opinion in 2014 in the Marshall case, in which it held that it was not improper when the state described the defendant's thoughts and circumstances that a victim did not observe. Rather, such descriptions were reasonable inferences from the record. And I would argue the inferences that were drawn in this statement about Debbie Faith watching her mother be killed were reasonable inferences from the evidence that was admitted in this case. Additionally, a couple of questions were raised regarding correspondence. Kathy Norman's description of decades-old correspondence regarding Sheila Faith and Debbie Faith. That I would first point out, there was no objection at the time that discussion, that evidence was admitted through that witness. There was no objection at the time, and while the state realizes that the lack of a contemporaneous objection is not fatal to the claim will still be addressed here. It does create a mitigating factor that opposes any finding of ill will or gross and flagrant misconduct, given that the state was never admonished on such an issue. Additionally, I would draw the court to the transcript of that exchange with Kathy Norman, because when you review the transcript, you'll see the state did not go out of its way in an effort to elicit testimony about an inadmissible letter that never came in this case. Rather, the questions that were directed to that witness were relatively open-ended, and the witness then spilled forth that she had seen letters to this effect. And as Justice Beyer mentioned earlier, there was extensive evidence from other witnesses and physical evidence that was admitted showing and supporting all of the issues related to Sheila Faith's habits. That evidence was extensive from other witnesses as well as physical evidence that came into the case, and one witness testifying that she saw a letter that was several years old from Sheila Faith indicating her habits in that letter is hardly grounds for finding error in this case, given the overwhelming evidence that went to that same point. Furthermore, on that same issue regarding the old correspondence, without any objection, the state asked, specifically in the transcript, the state had asked, was Sheila into kinky sex? And that's when the witness said, yes, she was. When Sheila moved out, I found old correspondence where she was into that. That was the statement. That is the extent of the statement that's being taken at issue here in Claim 62. However, there was no objection, as I stated, and the state then moved on to other issues with that witness. It did not elaborate on the contents of that correspondence. It did not delve into it any further. However, when defense got up and cross-examined that witness, defense counsel then went into extensive lengths to describe the information that may have been in that correspondence and asked several questions on that issue. That admission of that statement by Kathy was absolutely not grounds for reversal in this case or error. Additionally, there were questions that were raised about withholding the state's theory of a course of conduct until rebuttal, and that was Claim 61 in this case. In Claim 61, as is found in the blue brief, the state never withheld anything regarding its course of conduct or common scheme theory of the case. The defendant had been on notice for more than a year prior to trial as to what the aggravating that the state was seeking the death penalty in this case based on aggravating circumstances. And from not only the state's closing argument, but within all of the evidence as it was presented, and even going back further to the state's opening statement in this case, the state offered evidence, suggestions, and argument that it would be asking them to find an aggravating factor regarding common scheme or course of conduct. In the state's opening statement, the state mentioned they would expose many elaborate schemes and scams by the defendant to steal, exploit, to kill, and to cover up the deaths. That sentence right there summarizes the state's theory of the case that was utilized in opening. It was utilized in the state's first closing. It was then countered by the defendant in his closing, and then the state came back upon rebuttal and countered it again. The fact that the state used a PowerPoint presentation in the rebuttal closing argument is not evidence that the state was somehow seeking to sandbag the defendant with this information, because it was all information that already came in through the trial. The fact that the state may have used a PowerPoint in its rebuttal closing is simply demonstration that the state could foresee what the arguments were going to be in the defendant's closing, and that type of planning or preparation is not grounds for finding the state sandbag the defendant. Additionally, it was mentioned in the appellant's argument earlier that this court would certainly take issue if she had stood up here and requested 55 minutes of rebuttal time. But that's certainly not an analogous argument to the claim that's being made in this case. In a closing argument in a criminal case, first of all, my understanding is you're not allowed more than half of your closing argument time on rebuttal anyway. And that's certainly not what happened here. The first closing argument was very extensive. It was not brief. It was not simply just a preview of what I'm going to tell you later. Mr. Morrison went into great detail as to the state's theory of the case in both his first argument and his second. In the blue brief, pages 291 to 296, I outline all of the evidence that was admitted in this case to support the state's theory that was mentioned both in its first closing argument and in its rebuttal closing argument. Next, in terms of penalty phase misconduct claims that have been addressed earlier this morning, regarding the defendant's demeanor and the comments on his demeanor at trial. In this case, the state did comment on the defendant not crying throughout the trial except at one time when issues regarding his family were addressed. The state highlighted the fact that the defendant sat there at counsel table and he did not cry when the victims were mentioned in the trial, when there were descriptions of their bodies being removed from the barrels, and so on. There was no crying, there was no tears during that time, but then when there was testimony elicited about Mr. Robinson's family, that's when he cried. That statement, though, needs to be read in context. And if you go back to the defendant's closing argument, you'll see a quote from defense counsel where he said, "The guy I know, as you've seen, he's kind of quiet, he's kind of soft-spoken, he's polite, he's respectful." Defense counsel, in their closing argument, directly referenced the defendant's demeanor throughout the trial. They directly referenced him sitting there at counsel table by saying, "as you've seen," throughout this trial. They further went on and said, "The person sitting here at counsel table, he's been in jail for 29 months. He's a different person than the person that's going around brutally murdering women. He wants to be there for his kids and for his grandchildren." And so that's when, in the state's rebuttal closing argument, the state offered the statement about when the defendant cried, it was not about the victims, it was about himself, and it was about his family. That argument was absolutely proper, commenting on the defendant's demeanor in this case. It was proper rebuttal. Kleypas did, in fact, caution on this front in dicta in that case, but that's not determinative here, and this case can be distinguished. In this case, the comment on the fact that the defendant was not crying at other points in the trial is not a comment that was manifestly intended to target or highlight his silence. That's not what the comment was about. The comment was about his demeanor in the trial as he sat there.
But as perceived by the DA, right? I mean, this was his comment on what he believed to be evidence.
It was his comment on what he observed while he was there in the courtroom. That's true. It was observations.
Was that proper?
I believe it is when it follows a defendant's attorney in his closing argument standing up there commenting on his client's demeanor throughout the trial. I absolutely believe it's proper when that was first highlighted by the defendant.
It just seems to me that it takes an interpretation by the prosecutor, obviously who has an interest in the case, that could be completely off, but would then rely on common interpretations of someone crying. That bothers me. Would you comment on that?
I could, and I don't believe as though, I believe Mr. Morrison's comments could more be accurately be described as simply observations rather than his interpretation of what went on in the courtroom, because he was not going to extensive lengths. He made that one statement, that one sentence. He was not going on about what was going on in the defendant's mind. He wasn't commenting on what the defendant might be thinking at the time. He was commenting upon physical, visual observations that he had made. He was not interpreting them further. He didn't take it any further than to comment on the fact that he didn't cry at this point in the trial, and he did cry at this later point in the trial. So I don't believe it would be characterized as an interpretation. Additionally, in the state's brief, in the blue brief, pages 369 to 370, the state offers essentially a string cite to courts finding there is no error when the state comments on the demeanor of the defendant, particularly when you arrive at sentencing when character is relevant. This was not a comment on the defendant's silence. It was not repeated. It did not come up again. Regarding other misconduct claims that had been addressed, what were labeled as unfair attacks on Nancy Robinson. Nancy Robinson testified in this case, and she testified essentially because the defendant was seeking mercy in this case. He was seeking that, and that was an instruction that was offered to the jury in this case, was that mercy could essentially override any aggravating factors that the state had presented. And there were no unfair attacks on Nancy Robinson. Her testimony on its face shows her extensive, understandable bias in favor of her husband. And the fact that the state highlighted what she may have observed or may not have observed in this case or not a violation of any rules pertaining to closing argument. The state's allowed to comment on the biases or the prejudices that a witness may carry into the courtroom when they're testifying on behalf of someone. The state did challenge her loyalty to Robinson in that regard. In State v. Scott, the comments relevant to the question of sentence to be imposed were not improper, and that's essentially what these were. The comments claim 87, where the defendant is claiming misconduct related to the suggestion that Mr. Robinson may have internet access in prison, was absolutely not misconduct on the state's behalf to ask about that issue. Dr. Cunningham had testified on behalf of the defendant that Mr. Robinson would pose a low risk in prison to other inmates. Mr. Robinson had been previously incarcerated, and evidence that was admitted in this case showed he had computer access during his previous incarceration. If there isn't any more evidence that shows the question was relevant and was posed in good faith, it goes right to the evidence that was admitted by the defendant in this case. He had extensive computer programming access, but apparently the point's being raised that, well, he didn't have internet access. He had computer access, but not internet access during his previous incarceration. That was probably due to the fact that it was in the 1980s before internet access was essentially anywhere. So of course he didn't have internet access in the 1980s. On direct examination, the defense asked their own witness whether or not the Kansas Department of Corrections allows internet access by inmates. And the defense witness did not know the answer. That's what he testified to. He did not know. That's absolutely a relevant issue in this case, and it's one that's relevant for the state to comment on and to ask about. So then the state cross-examined. He said, we're not sure if he'll have internet access or not, are we? The issue seems to be taken with his use of the word we're instead of you're not sure, because the defendant argues that implies the state had some sort of knowledge about the level of internet access that the defendant would have. I would argue the we're versus your is entirely irrelevant. That is not the type of comment that would be picked up on by the jury. The focus of the issue was, is he going to have internet access in prison or not? And the question itself was posed in a way that allowed the defendant to answer the question. Also, the defendant lodged no objection at the time. That was claim 87 regarding misconduct issues. There were not there were not arguments made regarding voir dire in this case about the jury selection process, but there are a few issues that I would like to address in my time here.
I'd like to address particularly juror number 39. There was a sentence in that particular discussion that caught my attention that I read a number of times. Apparently, the analogy was being used of a football field where one goal line or one end zone was guilty and the other was innocent.
Right.
Correct? And juror number 39 said she was starting at the 20-yard line on the guilty side.
Right.
And you say the presumption of innocence does not necessitate that a juror enter the case at the middle of the field. What does the presumption of innocence mean if it doesn't mean you start without being on the guilty side of the field?
What it means is that when a juror is seated and it takes their oath to hear the case, they must set aside all preconceived notions of the case. Any evidence, any statements they've heard through the media, or any other personal knowledge they have of the case. And they must agree to decide the case solely based on the evidence that comes in at trial. They must, at the outset, presume the defendant is innocent. I would also argue it took me quite some time in going through the transcripts during jury selection on this case years ago as the brief was drafted to fully understand defense counsel's analogy utilizing the football field. He did not always preface that or describe it as one end of the football field is guilty, one end is not guilty, where are you on that football field? There were several people who said things along the lines of, I don't have knowledge.
I don't care what he says. I'm asking you about what you say in the brief, that the juror, what it reads to me is the juror doesn't have to start out neutral. When I read the presumption of innocence would start at the goal line at the innocent end.
Right.
It's not presumed not guilty, it's presumed innocent.
Right.
And so I don't understand how you can make that statement that the juror doesn't have to start the trial presuming the defendant is at least being neutral about whether the defendant is innocent.
And I absolutely agree with you that starting the trial, he must presume innocence. That is absolutely true. I'm not trying to minimize or downplay that presumption that the defendant is entitled to. I think the issue comes up and is a bit cloudy in the context of jury selection when there were several questions going around and lots of discussion about the media and about what jurors had been exposed to before they came into the courtroom. The questions about the football field were often raised in the context of jurors and counsel stating things that had already been publicized in the media and asking, because you've already heard something in the media, where are you along this football field? And that was usually followed up with conversations about the burden of proof and about the presumption of innocence, and saying that even if you find yourself at the 20-yard line or somewhere else when you came into the courtroom because you had information, Do you understand that whatever you brought in must be set aside before you could sit and take an oath on this case?
And that sounds real good, but this juror said the defense is going to have to put on evidence to move her from the 20 back to the 50-yard line.
And juror 39,
Why isn't that, if the defense has to move the juror, the prospective juror, to neutrality, why isn't that a cause for dismissal?
if juror 39's entire exam is read in context, I believe you'll see that she agreed to presume the defendant innocent. She agreed to weigh all the mitigators and aggravators. She never stated she'd automatically impose death. Upon a conviction, she repeatedly stated that her decision in the case would depend on the facts that were presented at trial, and her penalty would depend on the particular circumstances that were offered. That's the state's argument that is offered in Claim 6, which was, the subject was Juror 39. Also in Claim 11, referenced Juror 39. In Claim number 11, where Juror 39 said that the defendant should, that someone should be punished to the highest extent possible, well, that's certainly not in violation of the law. Also, Juror 39 and statements regarding the football field were also raised in reference to Juror 39's questionnaire responses that counsel had brought to the attention of the court and thought were grounds for excusing for cause. Judge Anderson cited in referencing Juror 39 that such individualized statements, including those on the questionnaire, should not be viewed as a Malaysian tiger trap. They need context. They need the entirety of the court's observation of that juror. Additionally, elsewhere within jury selection, Judge Anderson went out of his way to cite the fact that he was observing each juror as they were being questioned. And he was observing their demeanor, their body language. He was observing them in small section questions that were addressed when they were in small panels. He was observing their demeanor in the large groups, even when they were individually examined regarding hardship issues. And Judge Anderson, in reference to a couple of different jurors, stated, there are some jurors that have come through this courtroom, in effect, I'll summarize what he stated, which was, there are jurors who have come through this courtroom, some of which their statements may appear on the record as being essentially identical. But I made different rulings regarding striking them for cause. And my different rulings are based on the observations I made here in the courtroom. My observations of their demeanor, how they carried themselves, and how they responded. Where one person said, I cannot agree that I would ever be able to find any mitigators would outweigh the state's aggravators, a person was struck. And where another person was asked, well, could you envision mitigators that would outweigh aggravating circumstances in this case? He essentially said, I can't think of any. And that's the subject of one of the claims here, is that that person couldn't think of any mitigating circumstances that would outweigh the aggravators, and thus there was a problem in not excluding that juror for cause. But what Judge Anderson stated was, I was observing that juror, and when he said, I can't think of any, what he meant, what he was really driving at was, I don't know of any off the top of my head, but he was certainly not precluding himself from considering mitigating circumstances. He was absolutely open to mitigating circumstances, however they may be presented. There's not even an exhaustive list that's provided. And so he was open to that subject, and he told the court as much. And even when he said, I can't envision any, he followed that up later when he was examined on the same issue. And he said, I can't imagine any, but I don't know what my options are. And defense counsel said, good point. That's a very good point, because they weren't being given a list of options to choose from in jury selection. Juror 39 was also the subject of Claim 23, another claim that was addressed in both briefs and in Claim 23, the one where he placed himself on the 20-yard line toward guilt. I would respond further on that issue that in the Ransom case, it was found not to be error to refuse to strike a juror who said she may have difficulty. Her words were, she may have difficulty presuming innocence. The fact that somebody professes they may have difficulty presuming innocence is not in and of itself a demonstration that they were absolutely an impartial juror. Juror 39 repeatedly stated on exam that she would be open-minded and that she would hold the state to their burden of proof. There were other jurors that I believe may have been addressed in the appellant's case, and I would rest essentially on the state's brief on most of those issues because several of them are one-off comments or one-off statements, but I'd be happy to address any of them individually if the court has any questions about any of those issues that were raised throughout. The defendant's essentially claims 5 through 34, all about jurors who were retained over defense counsel's objections or motions for excluding for cause. Regarding the denial of the continuance request and the issues that were raised on that front, there are a couple of issues I'd like to address. Regarding the retention of an expert in this case, the denial of the continuance at the last minute, I would draw the court's attention back in this case to September of 2001, fully 1 year before trial. That's when the defendant requested a continuance of the trial and requested to continue the trial that was then calendared for January of 2002. So the trial was about 4 months out, and in September, defense moved to continue that trial date. And in the motion, and in the request to continue the January 2002 trial date, the defense cited the need to develop mitigation evidence, neurological examinations, family interviews, and so on. That was all raised in September of 2001. And the defense stated they would need as much as, their words were, as much as a year to develop a mitigation case in September of 2001.
My recollection is that the judge said, barring an extraordinary circumstance, there would be no
Yes.
further continuance. I'd like to hear your response about finding out that the mitigation expert who had been retained had not done any work, and whether that qualifies as an extraordinary circumstance or not.
The state doesn't believe it does. There was one mitigation expert, the one I believe that was referenced previously from Chicago, that they found out had not done some work that they thought she had. But the one mitigation expert was not the only person employed to address the mitigation case. The mitigation case was being tackled on several fronts. There were family interviews, there were neurological exams that needed to be done, there were interviews of the defendant that needed to be done. And so if there was an extraordinary circumstance, it was not related to the fact that that mitigation expert at the last minute they found out hadn't done the work they thought she had done. That lies with defense counsel, frankly. It was their duty and it was their obligation. They actually stated that's why we need 1 more year. In September of 2001, they say we need up to 1 year to develop our mitigation case. And the court granted it. The court granted the continuance to September of 2002. And the mitigation expert was hired.
Excuse me, I'm sorry. So it wasn't an extraordinary circumstance because it was the defendant's counsel's fault for not following up? Is that your point?
That would be part of the reason.
Okay.
But the primary reason why that would not be an exceptional circumstance, in Judge Anderson's words, was that he had given the defendant more time on the mitigation case, and the mitigation case was being developed on several fronts. They weren't relying solely upon this one expert who then, on the eve of trial, came forth and had nothing. I believe there was extensive other avenues that the defendant argued in mitigation, and that they had developed their case through those means. Additionally, the primary argument that the defendant makes in the brief is that the exceptional circumstance in this case that should have allowed for the second continuance was because one attorney withdrew and others were appointed on this case. But when you go back to the transcript and when you view in September of 2001, when the first continuance was granted and they set a firm trial date of September of 2002, there was actually a discussion on the record that was had about the defendant has 3 or 4 attorneys right now. And we don't want to get to the point where we get on the eve of trial and only 3 of the 4 can go forward. He actually stated, essentially finding that would not be the type of exceptional circumstance I'm talking about that would justify a further continuance of this case. And throughout claims 41 and 42, that's essentially, 40 and 41, That's essentially the claim that's being made, is that the denial of the continuance violated his right to counsel of choice. But it was clearly stated on the record that one of the several attorneys that were working for the defendant stepping away from the case would not be considered such an exceptional circumstance. Additionally, throughout that period of time, after the first continuance was granted and before the trial date a year later, the defendant never sought additional counsel. He never requested of the court additional appointed counsel. He never requested of the court additional funding or information for experts. He simply sought more time to do the same thing that he had asked for more time to do a year prior.
Was there any objection when the death penalty defense unit attorneys withdrew?
There was not an objection to that. That the colloquy between the defendant and the court was fairly extensive when Mr. Bob Thomas came in on the case. And they actually went in camera and had a proceeding where the state was not present. And then they also had conversations in court. But it was clear on the record that the defendant was well aware, if he retained private counsel in July of 2001, then that necessarily meant that the death penalty defense unit was going to withdraw.
See, that I don't understand that, because the court ended up appointing other attorneys.
It did. The court found he was partially indigent.
And he was not partially indigent enough to have these particular attorneys, but other attorneys. That's what I don't understand, is if the fact that he hired someone precluded those that had been working on it for a year and a half or whatever, but it didn't preclude appointing new ones. That just doesn't make any sense to me.
My understanding from the record is, and forgive me, I'm not well acquainted with all of the policies and procedures that the death penalty defense unit is bound by or that they adhere to. But my understanding from the record was they stated, if Mr. Robinson hires private counsel, then we will withdraw. And the court had a concern about that.
But they don't withdraw without leave of court.
Absolutely.
So it wasn't their determination to make, it was Judge Anderson.
Correct. It was Judge Anderson's to make. And it should be noted that although a defendant has a right to counsel of choice pertaining to private counsel, when it comes to appointed counsel, his choices may be limited, understandably limited by the courts. He no longer retains wide authority or choice regarding his attorneys when it comes to appointed counsel, which is what the death penalty defense unit was. The death penalty defense unit was appointed counsel. They had filed extensive, there's a chart in the state's brief, they had filed extensive pleadings in this case. Before
Which is my point.
Right.
By allowing them to withdraw, the court actually caused some of the problems that caused the delay. Because they would have been on board with the hundreds of motions that had been filed and with where the case was at that point.
That's absolutely true. And I would draw the court's attention to the timeline of it, because Bob Thomas came in July of 2001, death penalty defense unit withdrew. And it was then later that year in September when the defense asked for a continuance, and they requested up to a year. So the defense had already been working with retained attorney Bob Thomas and attorneys Berrigan and O'Brien and Billum that had been appointed. They had already been working with them since August of 2001 and then into September of 2001 when the defense made their request for a continuance. They were already aware of the whole shift in counsel and the fact that that was going to change the picture of how they prepared for the case. So they had all of that as their backdrop when they came into court in September of 2001 and requested a continuance, and the court granted it. And so I don't believe as though retention of Bob Thomas in July justifies yet another continuance when that's information that everybody had at the outset.
Do you believe that Ms. Nichols mentioned State v. Haney? Are you familiar with that case in which we sent back for a resentencing on a departure motion because there was an absence of an opportunity to get an evaluation?
Yes.
Does that case impact our analysis under the issue here?
Well, it may impact the analysis to the extent it talks about the rule that would apply. But in that case, if I recall correctly, I don't have it here in front of me right now, but if I recall that case correctly, the defendant had pled and agreed to undergo some type of
Yeah. There is a little bit of a distinction here in the terms of the plea called for that evaluation.
precisely. So the parties within the plea said he would be treated or follow up or sentenced pursuant to the evaluation. And then the sentencing was set out from the date of the plea, a number of weeks, I believe. And when that evaluation couldn't be completed, they sought a very brief continuance simply of the sentencing hearing. And when we're talking about the continuance of a sentencing hearing where the parties had agreed the defendant would undergo this evaluation, it hasn't occurred yet. There was no indication the state was adamantly objecting to the continuance request for sentencing in that case because they needed the evaluation too. I think that can easily be distinguished from this case, which was a case that had been pending for over 2 years, that there were dozens of witnesses that were going to be testifying. There were over 1,000 individuals who had been summoned for jury duty, who had been sent questionnaires. And when you talk about one of the factors that's to be evaluated, it is inconvenience to the parties and to the court and so on. There would have been virtually none in the Haney case when it comes to continuing for a few days or a few weeks to allow for an evaluation. But when you talk about a capital case that's been moving forward for over 2 years, long after the preliminary hearing, long after dozens of pleadings and motions, hearings, and so on, then I think it is relevant that this is not the same.
What does the record reflect, in your view, with respect to this question I asked opposing counsel, whether or not the evaluation could have actually been performed even without the continuance? Does the state have a position on that?
The state does have a position, and the state's position is that that evaluation should have been done post-trial. It sounds illogical, and it would give pause to some to hear that, but it should have been done post-trial. According to the Cook case and the Lye case, both of those cases stand for the, if I recall correctly, those were the two cases that call for the proposition that if a defendant's going to show prejudice from the denial of a continuance request, he needs to show what the evidence would have been.
Your argument is that the defendant cannot prevail on this issue because they failed to present a proffer, essentially, of the evidence. But you're not arguing that even without the continuance, if they had been diligent, they still could have obtained the evaluation and presented the mitigation evidence.
Both arguments. I believe both arguments.
Okay, walk me through that latter part. Walk me through how, in the timeline of how this developed, how could the defense team have actually accomplished what they wanted to accomplish in terms of mitigation evidence, given the timeline that the court required?
The timeline that the court required, to get the full context of the timeline, one needs to necessarily go back to September of 2001.
Okay, I understand that that's a portion of your argument, but bear with me for a minute and just focus on from the point in time when the defendant sought permission from the court for Mr. Robinson to be evaluated.
Right.
What is the state's position that could have been accomplished in time to present mitigation evidence to the jury?
I believe
Yes or no?
yes, I believe some of it could have been done, and I believe as though the evidence, the testimony that was presented by the defendant in the penalty phase shows that he was able to do some of that work. They did call an expert who had evaluated the defendant, who had gone through. It was the expert that testified regarding internet access in prison. So there was an expert that testified on this case. It wasn't as though the one who dropped off the map was what the defendant was hanging his mitigation case on.
Right, but the defense is arguing that the experts that, as you put it, dropped off the map did so because the schedule the court imposed upon them made it impossible. Made it impossible for Mr. Robinson to have the evaluations which his experts claimed they needed.
Right, and I agree that's the claim they're making.
I'm just asking you whether you think that that's factually accurate.
They would have had time to complete the evaluations in the time frame. I'm not an expert, so I don't know what they could have completed.
So you don't have a position on that?
I don't.
Okay.
I don't. But I know that in September of 2001, all the parties talked about the mitigation case and that they needed time to develop the mitigation case. And that was a year before the trial. When the expert testimony was proffered in the motion for the continuance that was denied later in 2002, that's when that defense expert testified, I believe, I would need 8 to 10 months to develop a full mitigation case and do all the duties, do all the evaluations, perform all the tasks I would need to complete a mitigation case. And when the court granted the continuance in September of 2001, that's when they granted essentially 12 months more time, more than enough time for the defendant to establish his mitigation case. That's the state's position on that issue.
The testimony about the 8 to 10 months happened when again?
I believe that came in the motion. There was one of the defendant's motions for a continuance in which the defendant called witnesses. And I don't have, off the top of my mind, I don't recall when that was, when that hearing occurred, but that's my recollection from the transcripts was that there was.
You understand why I'm asking? I'm just trying to distinguish between the court being aware of the 8 to 10 month estimate at the time they gave 12, or
Right.
not being aware of that till later.
I understand. With regard to that framing of the question, absolutely. The court was not aware of the 8 to 10 month time frame that was being sought until after it granted
That
the
came
12-month
later.
continuance.
Yeah, that's what I thought.
Yes, in
Okay.
terms of timing. I don't remember the exact timing, but I do
Good
know
enough, that's all I needed.
it came
Thank
after.
you.
Thank you.
And let me just follow up what I asked Ms. Nichols also, was that to what extent do you believe the appellant is required to show or demonstrate prejudice from the denial of a continuance? What needs to be shown?
I believe what needs to be shown is what evidence he would have offered had he been given more time. And I don't believe it suffices to simply say we would have done more investigation, we would have hired more experts, we would have done MRIs or CAT scans of his brain and so on.
Specific evidence.
Specific evidence. And that's what this court has called for in previous cases, is that after trial, the defendant can absolutely complete that investigation and utilize that information in its later motion to show this is the prejudice that I suffered, because these later evaluations that were done showed this brain scan shows a brain abnormality and so on. This would have all been presented to a jury, and I feel as though that could have tipped the scales and so on. But it wasn't done in this case.
Counsel, I understood your answer to my colleague's question about whether you had a position on if the defense had enough time at the point they realized they were in trouble to get the evaluations presented to the jury, and you said you didn't have a position on that. You're not an expert on how long it takes, et
Right.
cetera. What about whether the defense had enough time to get it all together before the motion for new trial would have needed to be filed? I presume your position on that would be the same?
My position on it would be the same with two additions.
Okay.
Number one, the trial court did allow a continuance to the defendant to file his motion for a new trial. The defendant asked for more time to file that motion and was granted that time. He never sought an additional allotment of time. He was never denied any time. A time frame was set by the court. They sought a continuance that was granted, is my recollection. And so there was an extended period of time that the defendant was allowed to continue work. I don't believe as though it was ever raised in the motion for new trial that we needed more time for the motion for new trial to actually procure that expert witness testimony and so on. I believe as though when that expert heard pre-trial that the trial date is firm, no further continuances are going to be granted, my understanding, my recollection of the trial transcripts was that defendant essentially, that expert essentially stopped at that point and that they didn't pursue that issue any further. It also goes to the point where defense counsel mentioned that they had sought an evaluation but later withdrew that request, unsure of whether or not that evaluation would come back in their favor and fearing that if it did not, that it would go in the state's favor. And so they made a strategic decision essentially to withdraw the request for further evaluation. So with that, I believe I have addressed several of the voir dire issues, certainly not all of them. If the court has any further questions regarding any of the what's been labeled as anonymous jury selection or any of the other misconduct claims, I would welcome those questions.
Any more questions? Thank you, counsel.
Thank you.